When we were here last time, you ordered her to have the interlock installed on her vehicle. She is not driving the vehicle. It's not drivable. We just need to switch her to a portable.
Oh, no.
And a no drive.
She has nothing. And it doesn't matter. We ordered you to have an interlock in a car. You haven't done anything, and you're without any kind of devices whatsoever, right?
That was totaled, and it's at my house right now. But I'm in a rental car that I'm not driving, so I don't have a car to put it in.
So you have no device.
That's correct.
You're not being monitored.
That's correct.
This is not a good thing, Miss Lynch, because I ordered you to have a device. And from what I understand here, you never even went and got it.
It's because she doesn't have a vehicle to put it on.
But you come back and you say, hey, judge, I don't have a vehicle. I need to do something else. You just don't, out of sight, out of mind. That's not the way things work.
Judge, for that violation as well, we instructed her in court and sent a message for her to report to 49 following court to get further instruction over everything so that we could figure out things from there, and she never reported.
Stephen, Miss Lynch, you haven't done anything. They've literally bent over backwards to help you and do stuff, and you haven't done anything.
I wanted to come in today.
The only reason you're here today is because I ordered you here
Yes,
today.
sir. Yes, sir.
She goes with you.
Yes, sir.
Emailed, texted, call, nothing, you know?
I understand. Would you consider setting her a new bond or
Of
default?
course, 5,001. And then, you know, if she's unable to, then what's today, Friday, Monday, then we can talk. Okay?
It makes you stop.
Yes, ma'am. Thanks. You, Miss Allayia Williams? Miss Williams, I'm sorry? Ma'am, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge.
Okay.
On November 14th, 2024, the officer observed the driver of a vehicle not wearing his seatbelt, and the traffic stop was initiated. The motor vehicle was occupied by a front right passenger, the defendant. The officer observed a strong odor of marijuana emitting from the vehicle, and the driver stated there were no drugs or weapons in the motor vehicle. Prior to the motor vehicle search, the defendant stated she had a weapon inside the motor vehicle, and a search was conducted where the officer found a purse on the passenger seat containing a 9mm handgun and a bag containing a green leafy substance identified as marijuana based on training experience. The weight of the marijuana was 3.1 grams.
So there was a smell of,
There was an odor, yes, Your Honor.
so what happened with the driver?
I don't see a connected case for the driver, Your Honor.
Ma'am, I'm going to find that there's probable cause to go forward with your case. How old are you, ma'am? What do you do for a living? I didn't hear you. What did she
She
say?
said a DJ, Your
Oh,
Honor.
you're a DJ. Okay. And where do you work?
I just like bookings, parties, events, weddings, family reunions.
Okay. No more marijuana, ma'am. As long as you can abide, then we'll be fine. How much money do you make a month, ma'am?
800
On average, what do you say? What do you think?
in a week.
A month, on average. Are you able to afford a lawyer? You sure? Do you want to apply for a court-appointed lawyer, ma'am? It's okay. Let me give you a lawyer, okay? Just don't get in any trouble. Okay, all right. Do you mind giving her a lawyer, please? Or an application. I need you to fill out an application for me. Fill it out. And then I'm gonna have you sign a receipt of Victoria. We'll have you take a seat in the jury box while we find your lawyer, ma'am, okay? Please.
Judge, this is DWI PTI intervention. Ms. Harvey's been removed from the program. Harvey, yes, Judge.
I'm bringing him up.
Ms. Harvey?
Good morning, Mr. Horn. It's been a while.
I didn't have.
I was hoping you'd give me some good news.
Here we are, Judge.
Shh. What did she pick up? Don't. Stephen, do you have a room back there?
Yeah.
I don't know what to tell you, ma'am. You picked up a new case while you're on bond. We have one thing that we do when people pick up new cases, right?
This right here is the moment everything collapses. Picking up a new case while already on bond is the fastest way to lose all court sympathy. Legally speaking, judges don't have much wiggle room. Bond revocation is almost automatic. Question: for you watching, should courts give second chances here? Or is this exactly how the system is supposed to work?
To revoke her bond. Sorry, ma'am. She goes with you.
Judge, if we could, we talk about it right now.
Sure.
Judge, we'd ask for a $500 bond. Judge, this is, she was on the program for, it looks like about 8 months. I don't know if there were any other violations. I just been on this case for 24 hours. But I know the new law violations triggering what we're triggering. But I believe she was in compliance on the DWI program she was in compliance up to this new law violation. So,
Is that right?
oh, no.
Yeah, I mean, she was, but now they've, so I'll set the bond at 2501. Okay. But understand it's now time to decide what we need to do.
That's correct.
If she wanted to do something today,
An ankle monitor isn't just surveillance, it's the court saying you're one step away from jail. This is the judge tightening control while still leaving a narrow exit ramp. Miss one rule, miss one appointment, and it's over. Drop a comment. Would you rather sit in jail or live under 24/7's monitoring like this?
Judge, I'm just retained. Let me get her bond
Sure.
out. Yeah, Judge, may I have 6 weeks?
oh, 6 weeks is, the max I'll give you, it's 520 days old. I'll give you 30, but at that time, and if she gets out, she needs to come here immediately for bond conditions because I'm putting an ankle monitor on her as far as like, what does she have now?
That's part of the program, Judge.
Do we need to redo bond conditions?
She still has, Judge.
Has. Okay, she has to remain in compliance and you need to advise her that she got to remain in compliance with that. If that goes out, the bond is.
That's correct, Judge. I advise her upon initial consultation.
So here's the deal. She's going to auto-populate on Monday. Well, I bet she's going to bond out.
Yes, Judge.
So she'll be back here within the next 7 days. And then I guess we'll come back at that time, give you a little bit more time for you guys to decide what you want to do. But after that, it's plea or trial. Okay, Mr. Horn.
Thank you.
Thanks.
To let you know, I didn't tell you earlier, there was a time.
Give me good news.
Joshua Jones.
Oh,
So he's here for a PTI violation. He has picked up new cases.
come up, Joshua Jones.
I was just gonna ask you if we could withdraw. He's nearly a year past due. He owes us over $2,000. We don't want to get on the new case. Allow him some time to hire an attorney that can handle.
I'm okay with it. Yeah.
Okay.
Yes, that's fine. And so I will have to appoint him someone, you know. Mr. Jones, let me express my disappointment with you. You were was he in the PTI program?
To my knowledge, he had a previous
Or in the
attorney.
intervention program for DWI, and now you've picked up another DWI. You now face another 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one.
Yes, Judge. On November 17th, 2024, an officer was dispatched to a person down call at the 15,000 block Intercontinental Road, and upon contact, the officer made contact with a witness who advised he observed the defendant to be asleep in the driver's seat of his motor vehicle. Despite the witness's attempts to wake the defendant did not wake up, and the witness turned the defendant's vehicle off in order to maintain his safety. The officer observed the defendant asleep in the driver's seat of the motor vehicle and also had unsuccessful attempts at waking up the defendant. When the defendant finally woke up after the officer made physical contact with him, the officer observed an unholstered black pistol in the driver's door and 2 half-consumed alcoholic beverages inside the truck.
Drinking while driving?
Yes, Judge. And standard field sobriety tests were refused. DIC was read and the defendant consented to.
When a judge calls someone a complete and utter danger to the public, that's legal language with teeth. This isn't just punishment, it's protection. Driving drunk, armed, asleep behind the wheel, that checks every red flag box. Final question for you. Was this bond amount too harsh? Or not harsh enough?
Breath and blood. Blood was drawn due to the defendant being unable to give 2 breath samples.
Mr. Jones, I'm going to find that there's probable cause to go forward with the case. I am now finding that you're a complete and utter danger to the public, and I am taking away your privilege to drive. You will be signing an affidavit with me today promising me you're not going to drive, and I don't give a rat's behind what your excuse is if I find that you drive. I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Because of the nature of the case, because you have an open container, 2 open containers with the DWI, I'm now revoking both of your bonds and I'm going to set them at $25,000 each. Do you understand? He goes with you. I'll sign your motion to withdraw.
She's just staring
Come on around.
at the front. It was here.